Good afternoon, Mr. George.
Good afternoon, Judge. How you doing?
Good. Good afternoon, Bettina.
Good afternoon.
I've got Elisa Williams, who's a 125 case. Tim, your defendant is not here yet. I've got the YouTube on already. Yeah.
Your Honor, I would be looking for counsel for the defendant. I believe the last name is Mr. Spiegel. We've been working on this case for a while, and I believe it's going to resolve in short order, but we'd probably simply just be asking for an adjournment at this point.
Well, the law requires I set it out for 7 more days anyway.
Okay.
Glad to see you getting more into the landlord tenant stuff.
Yeah, I think it's starting to pick back up in earnest.
You haven't been plugged into these, but Bettina and I were discussing Friday. As you know, the moratorium ran out over the weekend. But for our non-payment of rent cases, we expect maybe things to be business as usual. We'll be continuing them 30 days and get them plugged into Keystone and see if we can get landlords paid and tenants paid. Ms. Williams, can you hear me? You need to unmute your mic. Is she at your office, Bettina?
No, Your Honor.
I could sort of hear it.
Well, we have, I'm sorry, we have technical staff here, so my internet may or may not go out.
Just like me.
Yeah.
All right, Ms. Williams, we're almost there. Could you unmute your mic? There you go.
Sorry,
That's
sir.
better. No need to apologize. Just stay right where you are. We're going to start here in just a moment.
Okay.
Your case is set at 125, but we got another case we need to do first. And we'll take care of that, and then we'll address your matter.
Yes, sir.
HOT in here right now. I went out for a walk with Judge Tomlinson at lunch, and it's hot here in the courtroom. Could be worse, I guess.
I think it's supposed to be cool a little bit and then kind of get hot again this weekend, but
Sounds
no
good.
complaint.
We're gonna have a house full. Is this the Nicholas Spiegel?
Yes.
Okay, I'm familiar with him. I don't see him in the pleadings anywhere, but here he is. Everything is up and running. Good afternoon, Mr. Spiegel. Can you hear us?
I can, Your Honor. Good afternoon.
Good afternoon. Is your client going to be here?
No, I don't believe Mr. Andres is planning on being here this afternoon. The parties are working toward a resolution. I believe Mr. George.
That's what Mr. George said. So let me call the case. This is file 211068 ST. Tim George is here on behalf of the plaintiff. Mr. Nicholas Spiegel is here. He's yet to file an appearance, but he is going to be appearing on behalf of the defendant, Charles Andres. Mr. George advised before we turn things on that he and Mr. Spiegel had been discussing this case. This is a land contract forfeiture with a fairly substantial purchase price, at least for St. Joseph County. I should place this on the record, Mr. Spiegel and Mr. George, and let you know if you feel there's a conflict. I know the plaintiffs, Mr. Sherman and Mr. Wenzel. This is a property at Fisher Lake. I live at Fisher Lake. I've been wondering what's going on with this house. Mr. Sherman and Mr. Wenzel made a number of improvements to it. Mr. Wenzel is the county employee. He is the county drain commissioner. And they're people that I've known for a number of years. I went to school with his aunt, but that's sort of everything around here. I sort of know everybody who comes in one measure or another. I do not know the defendant. Mr. George, does that cause you any discomfort from me handling this matter?
No, Your Honor.
Mr. Spiegel?
No, Your Honor. As you mentioned, I rarely find myself in your court, and without you having an anecdote about most people, I trust you'll be able to
That's
handle
true.
that.
All right. Well, this is a land contract case. Less than 50% of the contract price has been paid. I don't know if there's a balloon payment, but there's a substantial payment that alleges to be due. The law requires that I give at least one 7-day adjournment.
And Your Honor, if I could, and Mr. Spiegel can chime in here. In speaking with Mr. Shesky, who's handling kind of negotiations on our end here at the firm, we would ask if the court would be willing to do a 14-day adjournment. I think that things are moving rapidly towards a resolution. I don't imagine that we would be here for the next hearing, but Mr. Shesky is going to be on vacation for the rest of this week. So,
well, as I indicated, I have to do at least 7, but I can adjourn it farther. 14 days from today would be August 16th. Does that work for you, Mr. Spiegel?
At what time, Your Honor?
Well, let's take a look. Oops. I have about 10 different applications open here. 2:15.
Yeah, we can make that work. And as Mr. George said, hopefully things resolve and we won't have to be back here at all.
All right. To resolve the matter. All right. Is there anything else we should place on the record here?
not on behalf of the plaintiff, Your Honor, no.
I think we're fine, Your Honor.
Okay. All right. Thank you. I'll see you in 2 weeks. Tim, I'll probably see you sooner than that.
All right. Thank you.
All right. Thanks.
Thank you, Your Honor.
Miss Williams, while you're waiting here,
Yes,
I'm
sir.
going to advise you of your rights in a landlord tenant proceeding.
Yes, sir.
I thought maybe someone else would log in, but we got a little time before your case is actually scheduled. So I'm going to be addressing your matter. Guess What LLC, also known as Colonial Crest Apartments versus Elisa Williams and any others. Ms. Williams, as a defendant in a landlord tenant proceeding, including non-payment of rent, termination of tenancy, or other action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. I think I sent you that information. You have the right to a trial by a jury or by the court. Excuse me. I went outside. If the action is for non-payment of rent, which this is, the Michigan Department of Health and Human Services and our local agent, Keystone, or other federal program may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. The summons and complaint from the court case are sufficient, and you've already received that.
Yes, Your Honor.
If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above and have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be sent for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. So your manager, Josie, is here, but we need to wait a minute or two for Mr. Thornton to log in, and he'll join us. Makes it much quieter in here when the blower isn't on. It also makes it about 20 degrees warmer, so maybe it'll help keep me awake.
You're looking a little warm.
I hope I'll be all right. Josie, can you hear us?
Yeah, I can.
All right, thank you. Here's Mr. Thornton now. He's always on time. Good afternoon, Mr. Thornton.
Good afternoon.
Miss Elisa Williams is here. I've advised her of her rights while we were between cases. Josie Marino, your manager, is here, and Bettina from Keystone is with us also. This is a non-payment of rent case. The allegation is that rent is $780 per month. It looks like maybe something has been paid. You sent us a breakdown sheet, and just August rent is all that's due now.
Yes.
That's very good. Ms. Williams, I don't know if you're eligible for emergency housing assistance or not. Bettina, have you had any contact from this defendant?
No, Your Honor.
It was my understanding, Patina, that Keystone did pay some rent on this case. At least our ledger shows a Keystone payment, a recent one. Is that an error?
I don't see it in my database.
No, she's getting rental assistant help from Keystone. So they pay part of rent every month. So that's what those are.
All right.
Your Honor, I have the money to pay the rent. I'm just in the hospital at the moment and can't do it at least until Friday.
All right, well, that's fine. The law requires that I continue this for 30 days in a non-payment of rent case. And if you pay your August rent this weekend or on Friday, then you're good through August and it just goes back to normal. If you do pay the rent, no one's going to need to appear at this 30-day hearing I'm about to give. But the problem is we're kind of scrunched up at the end of the month. I'm going out of state for a wedding.
Okay.
And I miss August 27th and August 30th, and September 6th is Labor Day. So I'm going to set this for 30 days from today, which is Friday, September 3rd at 2 o'clock. Does that work for you, Lance?
I'll check real quick here, Your Honor.
Excuse me, Your Honor.
Yes,
I just owe August rent.
that's what it shows here. You August rent of $658, $55 filing fee, $75 attorney fee, and a process serving fee of $179.52. So those are the costs.
I
So
don't
the
have,
total
Your
due,
Honor. Sorry.
what?
I thought it was
The total-
490.
You thought it was what?
490 was the total that I owed. That
They
was-
show 658 plus costs of 838.30.
No, Keystone pays half of it, so I would pay 171, and it was 490 was what the text was sent to me was.
All right. Well, then you work with
That is
Josie.
your total amount that you owe over the months.
All right. It's important that you work with your manager. If the rent is all paid by you and Keystone, then nobody needs to appear. If it is not all paid, we'll address this on September 3rd at 2:00.
Okay, thank you, Your Honor.
Lance, does that work for you?
It does.
All right. All right, Ms. Williams, stay in contact with Ms. Moreno, and hopefully you can get this paid, and then I won't have to see you again, and you can get on with your life. All right, 30 days from today, 31 days would be September 3rd, I guess 32 days. All right, you're good to go, ma'am.
Thank
You can simply hang up. Good luck with your medical circumstance. Lance, our next case is not set until 1:35, but I've received a dismissal. Guess what, LLC versus J. Hart and any other occupants, dismissed without prejudice. Is that what you wish to do here?
It is, Your Honor. He has moved and vacated the premises.
Yes.
All right. All right, that will reserve any damage issues, but I'll go ahead and show that dismissal. All right, that finishes your afternoon. Miss Williams, I'm just going to release you from this. You can go back about your business. And you're done, I guess. I've got 3 cases left. And
Okay, I'll disconnect then.
all right, if he has any questions or anything, I'll email you, but I don't expect he's even going to show up. But all right, you're good to go. Thanks.
Yep. Bye.
Ms. Moreno, thank you.
Thank you.
All right, Bettina, that leaves us with the complicated case of Enchanted Glen versus Montaigne. That's 201692, and that's a termination of tenancy that's not yours. Then we have Stevens v. Brooks, which is land contract forfeiture, and that's not yours. And then we have Pleasant Rentals versus Hilton, which is termination of tenancy. And so that doesn't appear to be yours either. So I think you're off the hook.
All righty, sounds good.
If something comes up that I need your help, I'll send you an email, but I don't want, you got plenty of other work to do, so I'll let you get on with your business and I'll get prepared for my next matter. All right, thank you.
Thank you.
This makes for very boring viewing, but I'm just leaving the live feed on until the next parties log in. Well, our next hearing starts in 2 minutes. I've been working on answering emails and preparing the next few cases, but no one is here for our 145 civil matter. They've got a minute left. Hurry up and wait. I'm also required to, here we go, Mr. Groen is here. Turn the record back on. Good afternoon.
Good afternoon.
No sign of the defendant. I'll go ahead and call the case. It's 146. This is titled LVNV Funding versus Madison and Ream. It's a claim for $645.73. This is the time and date scheduled for a motion for summary disposition. Plaintiff is also asking for costs and attorney fees. Attorney Brian Groen is here on behalf of the defendant, which I appreciate. 5, 6.
Your Honor, I do have some good news on this one.
All right.
We have been in contact with the defendant, and is actually, as of a couple weeks ago, it's been settled in full. Stip to dismiss was mailed out last week, so I'm not for sure how the court would like us to handle that. As the court is aware, sometimes they feel that the case is done and they don't necessarily always return the stipulation back to us. So,
Well, I'm going to tickle for 7 days. If stipulation is not returned, do I have your consent to issue a dismissal?
you do, Your Honor.
In her answer, she mentions that she was amazed that the plaintiff would have the gall to go after a single mother and try to collect this debt. And I just thought, well, they don't do a background check on everybody suing. They don't know much about the people other than they owe the debt. although it isn't substantial, and I'm pleased that you worked something out for her sake. So,
I am
yeah,
too.
she hasn't logged in and she hasn't returned it. And thanks. And I guess I'll stay here and get ready for my 2 o'clocks. All right,
There you
thank you.
go.
I'll see you again. Usually we're here in the morning. The air conditioner is shut off here in the courtroom for reasons I don't quite understand. So sitting here in a long black dress, it's about 92 degrees here.
Well, at least it's not 100 degrees outside, because I can
Yeah,
imagine how
I
warm
had
it
a
would be in
pleasant
there.
walk at lunch. Yeah, I hold court outdoors. All
There you
right,
go.
anyway, she isn't here. She's not going to be here. And hopefully she'll return the stip. If not, I'll do an order of dismissal.
Sounds good. I appreciate your honor.
All right, thank you.
You're welcome.
All right, very good. All right, now we've got about 11 minutes until our next hearing. And it's probably really not worth shutting everything off and turning it back on. So we'll just sit here and hope maybe they log in a little early. I had difficulty this morning with the live chat. I don't wish to engage in that again, so I'm just going to let it run. All right, I'm going to take these other pleadings out and be back momentarily here. Oh, here we go. April, you need to wake up. We're here for your court hearing. All right, I'll put you in the waiting room. We'll be back shortly. Oh, I lost Janet Glenn. All right, it's 1:55. This matter is set for 2. We have the manager from the department and the defendant are here. Turn the record on. Good afternoon.
Good afternoon, Your Honor.
Waiting for Mr. Hughes to log in. The defendant is here and your manager is here. Here's a phone number. Let's see who this is. Good afternoon. Who am I speaking with?
Hello, this is Dan
Hello.
Pellegano.
Okay.
Dan Pellegano.
I didn't think you were set till 3 o'clock. Let me look here.
Oh, I have to wait till 3 o'clock.
Well, you can certainly log in now, but your hearing isn't set until 3 o'clock.
Okay, I can call back then.
Yes, that would be good. All right, thank you.
Thank you.
Had a lot of people today log in on the wrong day or the wrong court or
Yes,
the
I've
old day.
seen that too.
If they had driven over here an hour early, I guess they just sit and wait. Or if they come to my court and they were supposed to be next door, we just sent them next door. But there's a lot of curating that's done from here on the bench through the Zoom function. Surprised Mr. Hughes isn't here yet. He's usually very timely. April, you need to wake up again. April. Miss
Yes.
Montaigne?
Yes,
All right. Okay.
I'm sorry. I my back out.
Here's Mr. Hughes. I'm calling the matter of Enchanted Glen versus April Montaigne. File number is 201692. Brianna Kingsley is here for the plaintiff.
Good afternoon, Your Honor.
Law firm. Mr. David Hughes is here for the defendant. Mr. Hughes, your client is here, but she's mostly asleep. April.
Yes, sir.
All right, your case is being heard, and I want to make sure you can track what's going on here today. You're not looking real with it. How are you doing?
I threw my back out this morning, sir. I'm in a lot of pain. I'm sorry.
Are you on pain medications?
No, I just woke up about an hour ago.
All right, well, all right, see if you can stay awake through this.
Yes, sir. I'm sorry.
Okay, and also the manager from Enchanted Glen is here. The Enchanted Glen Apartments have been trying to get the defendant to move since last October. Notice to quit was filed on October 10th to terminate the tenancy. The defendant retained Attorney Hughes and filed a jury demand, and that's the bugaboo. We've been unable to schedule a jury trial. There have been a number of things going on, discovery-wise and deposition-wise and some other things since last fall. We have just now, I have scheduled a number of misdemeanor jury trials starting September 15th. But this landlord tenant matter isn't going to supersede a domestic violence case or some other sort of case that's already been set in there. So the trick is try to find a place to put this. Anyway, I adjourned this for summary disposition filing. It doesn't appear one was ever filed. and it is a discovery. Miss Montaigne has represented since last fall that she was looking to find another place to move to, and that would solve this problem. But I'm not sure what our status is. So,
Your Honor, if I may,
yes.
my understanding is Miss Montaigne has been approved for housing in the Coldwater area, and she's just waiting for them to get some paperwork back to her, and there is a unit available as well. So my understanding is that she will hopefully be moving here in the next couple of weeks, presumably by the end of the month at the latest. So,
Your Honor, my motion will be out by the end of the week. I have probably about 50 exhibits, so it's taken me some time to get through all of those. But if I may, I am not sure if the defendant has still been paying her rental charges into escrow with the court. So at this point, if she's defaulted on her escrow payments to the court, I would request that this matter be set for a bench trial.
That's a very good question. April?
Yes, sir.
When did you last pay rent?
I'm not sure. I mean, I have all the rent saved in an account, but I'm gonna use it to move. You know, it's already been hard for me to even find housing, and I had to go to a different county to find it, so.
Then at this time, Your Honor, I think that the jury trial can't be preserved and that this should be set for a bench trial.
Yes.
Your Honor, if I may, I believe the order was that Miss Montaigne was to pay the rent directly to Enchanted Glen, not to the court.
Yes, sir.
I don't.
She hasn't been paying it.
Well, we haven't had any testimony that she is past due.
Your Honor, my client is here and she could testify right now.
All right. April, I'm very concerned about your ability to participate in this proceeding. I don't want to be unkind, but it looks to me like you're crashing.
I'm not even sure. I don't know where you're seeing this. I'm away.
All right, you keep falling asleep. All right, who is here from Enchanted Glen?
Your Honor, that would be the property manager, Kathy.
Yes,
Kathy, what's your last name?
Williams.
Would you raise your right hand?
Yes, sir.
You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir.
When did Miss Montaigne last pay rent?
I believe it was in May of this year, sir. I will have to pull the file, but
Please do.
yeah, pretty sure it was in, I'm sorry, pretty sure it was in May of this year.
All right, well, we got to go with more than pretty sure.
Well, I can tell you, Brianna,
We
do
would
you
have
have
dealt with
that?
this a long time ago. Okay.
Yeah,
so-
Kathy, I do have the ledger. I'm showing the last payment received was in March.
I'm sorry, okay.
I can give you a bench trial date of August 18th. at 2 p.m. Block out the rest of the afternoon. However, some reluctant to put everybody to all the effort to prepare for a bench trial if she's going to move. And, but I've heard that story many times. I'm about to move, there's a new place coming, the check's in the mail. Only
Or
had
if I
2
may,
weeks.
if I may, sir, I already signed all the paperwork and everything. I'm just waiting for it to come back from the regional manager.
All right. Ms. Williams, can you answer the question about when rent was last paid?
I think Brianna has that in front of her, sir. I don't. If I go into
All right,
my
so
file,
what-
I lose you.
Your Honor, the last payment was received in March of this year.
Your Honor, I don't believe counsel can testify for a client. I'd object to.
Yes.
Kathy, can you pull up the ledger on your computer?
I can, but I might lose you folks. I'll try to, if I lose you, I'll get back in.
Well, hang up and dial back in, but
Yes,
this
sir.
is important.
Yes, sir.
This is distressing.
Okay, let me see what I can get done here.
Your Honor, if we do set a bench trial, as of the 18th, I don't know how long the bench trial will take. I'm coaching football and we have practice starting at 3 p.m. Are there any earlier in the day trial dates that week?
Well, let's see. No, let's see what we got.
I do still plan on filing my motion for summary disposition by the end of this week as well.
Again, those are a lot of billable hours and a lot of work to go to if she would just move. But I think if we could have had a bench trial months ago, there probably would have had the issue resolved. But do you have the same issue every Wednesday, David?
Well, basically that week is 2-a-days. Practice doesn't normally start until 4 the following weeks after that. So,
Well, even 4 isn't going to get it because this is going to take several hours, and I don't just have blocks of time laying around. But if she hasn't been paying the rent since March, and they've been trying to evict her since October, this case has had the jury trial sword blocking any further activity. She's not paying the rent. She's not entitled to have a jury trial under the escrow order. And I'd rather try it sooner than later, but I need a block of time to do it. And the judicial conference is in August. Judge Welty's or Judge Patterson's on vacation, some in August. And I don't just have time laying around.
is there any? I'm sorry, Your Honor. Is there any way we can start earlier in the day that day or no?
No, I have other things already scheduled. Maybe my own fault for trying to cram it in here, but I didn't account for football practice when I scheduled out my October calendar.
If
Perhaps we could start at 9:30 on the 18th. What's SBF? Maybe 9 a.m. on the 18th.
I'm available then, Your Honor.
Okay. Again, my hope was at some point that Ms. would be able to find other housing. But I don't know how hard she's professed that she's looked all over the place, and I'll take her at her word, which indicates how hard it is to find other housing. It's even harder if you indicated your reason for leaving was because you were evicted from your last housing. So Mr. Hughes has been trying to avoid that, but she's abused the privilege. We've gone from October, starting in November, through the escrow order, and she stopped paying the rent in March. That's not fair to Enchanted Glen. March, April, May, June, July, August, unpaid rent. And if I'd known that when we were last here in June, I probably would have scheduled the thing sometime for the summer. She doesn't want to move. She doesn't want to pay rent because she wants to save it for the next place. And we're on the cusp, apparently, of moving to the next place. And I'll be here either way, but I don't really wish to put either of you to effort or expense if she's simply going to move. She also appears to be sleeping through most of these proceedings.
Your Honor, I did find this for you.
All right, this is Miss Williams once again. When was rent last paid?
She paid it on, the last was March 18. She has not paid anything since April of this year. At $584 a month.
Was the March payment late?
Yes, sir. She caught up. She made two different payments, two different checks. I'm sorry, one for $1,000 and one for $387. And that brought her to a zero balance in March 18th. And then nothing since that time. So all of April, May, June, July, and now August.
That's 6 months. There's 3480. All right, I'm gonna set the matter for bench trial for Wednesday, August 18th at 9 a.m. That may be a bit ambitious because they're probably going to stick more stuff in there, but I'll have the morning and maybe into the early afternoon if necessary. My hope is, April, that you will move and
Yes,
none
sir.
of this needs to be done.
Yeah.
Because this may affect your ability to move into the next place.
It's going to. That's why I've been trying to move.
Well, all right. Well, stopping to pay the rent didn't help your cause.
Your
I
Honor.
understand trying to take care of two things at once. Yes?
Your Honor, I would also like to make a note that even since the last time that we were here, the defendant continues to violate her lease agreement. Back in April, I had to issue her a trespass letter from the management office after she engaged in verbally abusive behavior towards my client.
I'm
And
sure, may I say something?
April,
Actually,
no.
what the heck?
on top of that, she's continued to have lease violations for an unauthorized animal. There's been police presence, numerous complaints from other residents. So at this point, we're ready to proceed to a bench trial.
All right. It will be April 18th at 9 a.m. unless she agrees to move. All right, April. This isn't a laughing matter. You can call Mr. Hughes and discuss this with him. But unless you're moving, we're going to have a trial on April 18th at 9 a.m. So the sooner you move, the better. That also may cut off their nose to spite their face if they jeopardize your next tenancy. But nonetheless, trial April 18th at 9 a.m. unless I'm told otherwise.
Your Honor, will that be in person or via Zoom?
Via Zoom. That's a good question, David. Zoom is well adapted to this type of proceeding. We're starting to do more criminal matters live, but we should be able to do this by Zoom, so I'll note that also. Thank you for asking. Anything further?
Not at this time, Your Honor. Thank you.
Nothing, Your Honor.
Ms. Fontaine, you contact Mr. Hughes and keep us posted. If you are going to vacate, that could solve the whole thing. I'm not going to speak any further to that situation. You guys saw the same thing I saw. Hopefully she can make it.
I didn't, Your Honor. Did she make an inappropriate gesture or something?
No, she just was sleeping through the whole thing.
Oh,
And I have a guess as to why, but we'll address that if we have to. All right, thank you.
Thank you, Judge. Have a nice day.
Oh, thank you.
Thank you, Your Honor.
Thank you. I'm gonna just cook Mr. Hughes out. I had additional person I just lost, Mrs. Bailey. You're Christopher Lecter?
I am, Your Honor.
Good afternoon. Which case are you here on?
I'm here on the land contract matter at 230 Stevens versus
Stevens and Brooks. Are you here on behalf of the Brooks?
I am. My office just sent to the court my appearance and an answer electronically. I'm not sure if you have received it.
I haven't yet, but I'll see. Lupita, did you get an appearance and answer on Stevens and Brooks? Let's see who this person is. It might be Casey Brooks. Who am I speaking with?
I'm Jason Stevens.
All right. I just had Mr. Hughes and I removed him from our last hearing. He'll have to relog back in. Let me look in the on-base file and here it came. Thank you.
You're welcome.
Well, I guess we're not set till 2:30. Mr. Letcher, what's your P number?
72282.
It's Letcher?
Yes, sir.
I'm sorry if I mispronounced it.
No, not at all. It happens all the time. It's not a common name. So
I went to school with a girl named Letcher, so many years ago. All right, let's wait for Mr. Hughes.
I believe that the defendants intend on appearing as well.
I'm here, Your Honor.
Yes, Mr. Stevens, I've got you logged in. I can't see you, but I can hear you.
Sorry, I'm at work.
All right, well, you're here.
Yeah, I'm multitasking.
Yeah, aren't we all?
Life in the Zoom world.
Yes. Well, I should have left David on the feed. Is that you, Mr. Brooks?
Yes, sir.
Is Casey with you?
She's getting on her phone right now.
All right, here she is. We're waiting for Mr. Hughes, the plaintiff's attorney. We've got everyone else we need.
Wait, first one?
Yeah, there she is. We're on the live feed, we're on YouTube, we're on Zoom, and we're recording. So keep that in mind. I'm making some notes on our last case, so I'm waiting for the attorney to log in. I had Mr. Hughes on our last hearing, and I removed him. If I'd been thinking, I would have just left him on the feed, but waiting for him to log back in. Well, I'll invite Mr. Hughes to join us. Here he is. All right, Mr. Hughes is back with us, and we can call this case. It's entitled Jason Stevens versus David L. Brooks and Casey N. Brooks. Mr. David Hughes is for Jason Stevens, who's present by telephone, I think from California. Mr. and Mrs. Brooks are present. They mentioned last time they had talked to legal aid, and I received an appearance just about 5 minutes ago from Christopher Letcher of Legal Aid for Western Michigan, and an answer. There was discussion that the defendants had tendered or were prepared to tender $6,000, and there was a discussion or issue whether it was payment in full or otherwise. So they now have counsel. And Mr. Hughes, had you seen that answer?
I'm actually just looking at it right now, Your Honor. I received it. It came in during our last hearing, and so I haven't had a chance to review it yet.
I was kind of in the same boat. I think we agree there's a dispute about this $6,000 payment, what it's applied to what extent. In the answer, he raises other issues about calculation of late fees and some other issues that are going to have to be resolved. At the previous hearing, I did advise the Brookses of their rights to have a hearing and have counsel at the hearing. The law requires that I adjourn 7 days, which I did. They did avail themselves of the effort to get counsel, and now they have legal aid. And now we have some new issues, which Mr. Hughes hasn't really had a chance to absorb. It sounds like this matter could be worked out with the defendants becoming current in the payments. There's also an unresolved issue of whether the insurance is current. I don't think we resolved that issue last time. Mr. Hughes, my thought may be that now that Mr. Letcher is here to continue this matter again, to let you and counsel for the defendants discuss this and see if you can narrow the issues. Do you have any feeling regarding that?
Well, Your Honor, Mr. Letcher and I have actually already talked. I think we're relatively, again, I haven't had a chance to fully read his answer yet. Based on our phone conversation, I believe we're within a pretty close window on the arrearage of principal owed, and I think we could resolve that. In this case, there's no interest. I think the defendants are in agreement on the amount of property taxes that are past due that we're alleging as well. Mr. Fletcher can correct me if I'm wrong. I think really the only three outstanding issues are, number one, the insurance issue. Number two, a dispute over the amount of late fees. And then three, I believe the defendants are contesting the attorney fees. So I think and honestly, Your Honor, the late fees issue kind of hinges on a determination by the court as to how those should be calculated, because we can present proofs back and forth as to what they are, but really it depends on what the court says how we need to calculate them. And honestly, if the court were able to make a ruling on that today, we could probably resolve that issue as well.
Well, since I just became aware of it about 9 minutes ago, let's look at the contract and see what it says as to late fees. If any installment becomes over 10 days overdue, there shall be added a late fee of 4% of each overdue installment. Payments are $50 per week. 4% of $50 is $2.
Correct, Your Honor. Now, my client's intent when he drafted that provision for the contract was that basically that 4% would keep accruing on the payment every 10 days. So if it's 10 days past due, a $2 charge on that payment. If it goes 20 past due, another, 4%, so another $2. So my client's intent and how we calculated the late fees was basically take the number of days it took to get that payment current, and then, dividing it by 10, applying that $2 late fee based on those number of days, which I think is fair in this case because no interest was charged. And I think if you amortize the interest over the course of the loan, it would be around $6,000 anyway, which is what my client's alleging for the late fee. So,
well, the plain reading of it, I read it the same way Mr. Letcher did. Any payment 10 days overdue, there should be a late fee of 4% over each overdue installment. So it's $2 each time they're late, which would mean a whole year's worth of late fees would be $104. But I read that the same way the defendant did. His intention may have been something else, but you have to do too much inferring. The plain reading of it says what it says. 4% late fee for each monthly installment that's more than 10 days overdue. So that would have a recalculation of the late fees. Do you think it'd be worth it for you to talk with each other in the breakout room? Or, well, I'm willing to do several things. I have another case set at 2:45, and I have about 6 small claims cases starting at 3 o'clock. So I have a limited amount of time to hear testimony or anything. But it sounds like you're fairly close with what the numbers are.
Well, Your Honor, if that's how the court is going to construe the late fee provision, that you can only charge once for every late payment, I think I can recalculate that, and I believe Mr. Letcher and I could probably come to an agreement on that, because pretty much, I mean, unless we disagree as to how many late payments there were. Again, the other two issues, the legal expense issue, if Your Honor looks at page 5 of the land contract, paragraph 17, it says that basically if the prevailing party in any summary proceeding is entitled to reasonable legal costs and attorney fees, again, just glancing through the answer, it looks like they say we're not entitled to that because we're not the prevailing party yet. However, assuming, a judgment is entered, which they're acknowledging they're past due on the principal. So I'm not sure how we wouldn't be the prevailing party.
Well, the Landlord Tenant Relationship Act prohibits a plaintiff from increasing the legal fees over and above the statutory $75. Question is, I'm not sure if this is summary proceeding, whether that Landlord Tenant Relationship Act refers to a land contract forfeiture. I don't know the answer to that. I'd have to do some research.
If I may, Your Honor, it's called the Truth in Renting Act, and it does not apply to land contracts. It only applies to rentals.
And I would submit, Your Honor, wherever the court comes down on that question, the attorney fee provision, I'm not sure that the contract states that it should, or I'm not sure that it should be included in arrears amount, or if that looks more like damages for the supplemental complaint. It's not principal balance, interest, or insurance payments. So the payments that are actually due under the contract, I think that I would submit that it shouldn't be included in arrears amount anyway, even if the court determines that attorney's fees are owed here.
Give me a moment. Well, the language specifically refers to a rental agreement. It's not 100% clear. The Truth in Renting Act, as Mr. Hughes pointed out, rather than the Landlord Tenant Relationship Act, 554.632 defines a rental agreement. That means a written agreement embodying the terms of conditions concerning the use and occupancy of residential premises. That's not 100% clear, but it does not specifically include land contract actions.
Again, I would point out here, Your Honor, that Mr. Stevens has received minimal payments for almost 3 years now. The court has ruled he gets basically $100 in late fees a year based on that, and there was no interest charged here, again, based on my client's misunderstanding of how to apply that late fee provision. So I think at the very least, being able to recover his attorney fees based on the defendant's not paying rent for 3 years is fair. Or excuse me, not making payments for 3 years is fair. And I believe allowed under the law and the contract.
I would counter that the defendants have tendered to the plaintiff $6,000 in the month of June, which are not credited anywhere in this complaint. And again, I fail to see how the attorney's fees relate at all to the terms of interest or the weekly payments that the plaintiff agreed to in the drafting of this contract.
Well, I tend to agree with both of you. I think that I'm going to have to do some further research, but I don't believe this is covered by the Truth in Renting Act, and it's in the contract, and the plain reading, just like the other plain reading, is that he's entitled to his attorney fees. I also agree with Mr. Letcher that this should be part of damages, supplemental damages, rather than part of the arrearage.
If I may, Your Honor, isn't any payments owed in the land contract are going to be a continuing lien on the property until they can get full possession rights to entitle them to a deed to be signed over. So I guess my question is, why wouldn't that be part of it? It's got to be paid before they can get title to the property. So why wouldn't that be part of the arrearage?
I'm not sure that's true. You said that. I'm not sure that what the law says. I'll have to take a look at it. The bottom line is we're not going to be able to resolve this here today. We're close, but we're going to need some probably testimony and further court rulings rather than seat of the pants or a ruling with a pleading that was filed 5 minutes before we got here, and closer look at the Truth in Renting Act and counsel's contention that it should be part of the arrearage. Those need to be addressed better. Oh boy. Mr. Hughes, could you do, we were looking at August 25th. Could you do August 25th at 2? What time does your other thing start? 3:15?
So practice that week doesn't start until 4, so 2 should be fine, Your Honor.
All right. Does that work for you, Mr. Letcher?
It does.
All right, we'll set this for hearing for Wednesday, August 25th. At 2 p.m. We're about to start jury trials again. And I've been stealing every Wednesday for landlord tenant hearings, zoning hearings, towing hearings, PPOs, and other things. I don't know, when we start using every Wednesday for a jury trial, we're gonna have to find another place to put this stuff. But for the last year and a half, I've been setting a lot of landlord tenant cases on Wednesdays that would have been a jury day. We don't start till the 15th of September. So I will continue this matter for further hearing regarding those issues. Insurance, late fees. Well, I gave you my tentative ruling on that. Attorney fees, and the amount of arrearage. And 2 hours hopefully will be enough time to address that. We can just focus on this. I have an ugly matter at 1:30, hoping perhaps we can resolve it in a half an hour and start this at 2. I'm starting to lose my voice. I've been talking all day. Yes, Mr. Hughes?
Your Honor, the insurance issue is pretty concerning to my client, because I mean, between now and speaking with Mr. Letcher, I believe defendants concede that the property is not currently insured. I guess I would ask that if I mean, between now and the 25th, the house could burn down, and my client's, out a lot of money. Could we have some type of order, if Mr. Letcher's agreeable, that if the property's not insured within a week, I don't know what the remedy would be here, but we need to get this insured to protect my client.
Sir?
Just a moment. Mr. Letcher, what's your thought regarding that?
I've spoken with my clients last week, and they've advised me that they are in the process of obtaining insurance on the property. They're aware it's an issue, and they're attempting to resolve it. In terms of, I acknowledge the plaintiff's concern over this issue.
I know.
Sorry. I acknowledge the plaintiff's concern over the issue, but again, my clients are aware of it, and they're attempting to cure it, and they will cure it with all speed possible. I'm not sure what remedy there would be.
Not either, except everybody's left holding the bag.
Right.
Defendants are directed to obtain insurance within 7 days.
We do. We do have
It's not-
proof of it.
Okay.
All right.
I'm sorry, Your Honor.
Very good. Share that with your attorney.
So,
Yeah, we'll email that to him directly as soon as we can.
All right. And I'll provide, when I receive that proof of insurance from my clients, I'll provide it to Mr. Hughes.
Very good. All right, we'll address this further in an hour and 40 minutes or so. How long it takes to get to football practice, but we'll do what we can do, hopefully starting at 2 o'clock on the 25th of August. That'll be a day to not look forward to, but we'll see if we can bring resolution to this.
And Your Honor, would you like any briefing on the legal issues, or?
Yes, if you have established, if you can establish, I'm going to do some research of my own, that the Truth in Renting Act applies to land contracts, that forecloses that question. You can't put a clause in a lease that changes the statutory attorney fees. The definition seems to speak to rental agreements, but the definition was broad enough that it could possibly include a land contract. So I need to, I'll read it again. A rental agreement means a written agreement embodying the terms and conditions concerning the use and occupancy of residential premises. And this is a written agreement that embodies the terms and conditions concerning the use and occupancy of a residential premise. So we need to explore that question further. And if either one of you have an answer, it would solve it. Yes, that would be helpful.
Okay. Thank you.
All right. Thank you. All right, Mr. Stevens, you can go back to work. I've got a number of other people waiting for the next cases, so I'm going to remove you.
I appreciate your time, Your Honor.
All right, Mr. and Mrs. Brooks, I'm going to remove you.
Thank you.
Thank you.
Thank you, Your Honor.
David, thank you, David.
Thank you.
Quite a bit here. Mr. Letcher, if you can solve that question, you'll save me a lot of time.
I'll start this.
And Mr. Brooks, I'll remove you as well. All right. We have one more landlord tenant.
Got back in.
All right, now calm down. I bring people in and they're like a deer in the headlights. Ms. Hilton, I will be with you in just a moment. And Mr. Belagano, you stay right where you are. Joyce. All right, that's Mr. Belagano is here for a small claims hearing. And Doris Hamilton is here for a small claims hearing. I'll put you both in the waiting room and we'll be with you in just a moment. All right, Ms. Hamilton, you practiced early this morning, so we'll see you here in a minute. All right, Ms. Hilton, let's see if we can address your case. Mr. John Bush is here on behalf of the plaintiff, Mr. Michael Kreitz.
You should also be hooked up on my office too on the other.
He is. Let me shift gears here and set these small claims cases aside. This little case. This is the second hearing in the matter of Pleasant Rentals versus Terry Hilton. It was filed as a termination of tenancy on a month-to-month tenancy. We had our first hearing on July 26th. The matter was continued for the second hearing today. The plaintiff desires to terminate this tenancy. The lease has expired and he wishes to have his property back. Is that correct, Mr. Bush?
That is correct, Your Honor.
Ms. Hilton, what's your position?
Currently at this second, nothing. I've been looking. I have a place possible real soon. I gotta check back with them.
All right. Mr. Bush, let me see if you sent me a order. I don't see.
If I didn't, I will promptly get one to you this afternoon.
All right. I don't see one here. I've been busy. I got things discombobulated, but I don't believe there's one here. This is a termination of tenancy, Ms. Hilton.
Yes.
And so he simply wants the property back. These are the most difficult types of cases that I have to deal with. It's not alleged that you violated your lease. It's not alleged that you haven't paid the rent. They simply wish to terminate it. I've got a couple where the owner wants to sell the house and they need to get the tenant out before they can sell it. The law says you have 10 days from today to move, or you're subject to being evicted.
Okay.
So Mr. Bush is going to submit an order that says you have until August 13th to move.
Okay.
And appeal.
3/4 of it done, packed up and already in the storage, so I will be out before the 13th.
All right. When you move, you need to turn in your keys and give your forwarding address in writing. That triggers the security deposit law, and then we'll deal with those issues. Okay?
Okay, as soon as I get a new address, I will.
All right. Do you have any questions?
No?
All right. Mr. Bush will submit an order.
Thank you, Judge. We'll take care of that. We'll get it over to you this afternoon.
All right. Thank you.
And thank you, Judge.
Okay. Thank you, Ms. Hilton. Good luck to you.
Yeah, thank you very much.
All right, Mr. Kreitz, you're good to go too. I hope she finds a place to go. All right, that completes our landlord tenant docket. I've got a lot of notes to make. And it begins our 3 o'clock small claims docket. So I'm going to bring everybody in. Good afternoon, everyone. It's 2:58. Our small claims will start here in just a moment at 3 o'clock. I'll turn the record on. These are small claims proceedings. They aren't made of a formal record, but I turn it on anyway in case I need to review something. We are live on YouTube and we are on the Zoom platform. First matter I'm going to bring up is, let's start with, well, Advantis. Sarah Sargent is here on behalf of Advantis. Ms. Sargent, what's your position there?
Billing assistant.
And would you raise your right hand?
Yes.
Do you swear or affirm any testimony you're about to get in this matter will be true to the best of your knowledge and belief?
Yes, Your Honor.
This is an asset discovery hearing.
Want me to come get the dogs?
They're in their other room.
Oh. How do I?
All right. Mr. Dustin Schmiddendorf was subpoenaed to be present for this hearing, and people routinely don't show up on time. There was a judgment entered in the amount of $346. Ms. Sargent, what additional expenses do you have?
That was our final price for him, was the $346.78.
Yeah, but you have a subpoena cost of
yes, Your Honor, I'm sorry.
$47.84.
Yep, so our final price was $409.62.
And I think there might be a subpoena fee of $20. All right, defendant has failed. Has he made any payment on this?
No, Your Honor.
Do a bench warrant for his arrest. Find he's in contempt for failing to appear pursuant to a subpoena. Bond is $430, cash only. May be applied to the debt. All right, I'm going to ask you to stay on the feed for a moment in case he shows up late. People are not very conscientious. I can't make it any easier for people than to dial in. In the old days, they'd have to drive here to the courthouse. They still don't show up. Mr. Bellagano, we're going to do the same thing in your case. Give me just a moment here to see what we got on Mr. Stager. There's two Stagers. There's Gene Stager and Bradley Stager. Well, how did they get a subpoena served on him? There's an open warrant for his arrest. Huh. I believe Gene Stager is Kim Eugene Stager Jr. And there's currently an open bench warrant for his arrest for failing to appear on a methamphetamine case. He was to be here today for this case. So this is file 191627. Mr. Stager has a trail of dissatisfied customers from his lawnmower repair business. Mr. Belagano has been very diligent in attempting to collect on his case. Mr. Belagano, would you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, I do.
Has any payment been made on this?
No.
Perhaps the reason he didn't get arrested is because he's listed here as Gene Stager. I believe his name is actually Kim Eugene Stager Jr. But he was personally served by Sergeant Morse for today's hearing on June 25th. Mr. Belagano, I will tell you that a couple of people have actually gotten paid by him by doing what you're doing here. The debt is, oh darn it, I don't have a copy of the original judgment in here. $1,081.15 plus service fee of $41.28. $1,222.43. 1122.43. Bond is $1,122.43 cash only. May be applied to the debt. Defendant failed to appear, is in contempt. I would know there is an open warrant for his arrest. It may not have been outstanding at the time Sergeant Morse served him. Yes, it was. It was issued in April. In file 20706FY. Meth case. Mr. Belagano, we got to catch him first. There's an open warrant for his arrest, and there in fact was a warrant at the time Sergeant Morse served him. His name is Kim Eugene Stager Jr. But we aren't going to be able to do anything for him. I set a cash bond in the amount of the debt, and he failed to appear. So once we catch him, he's got to post that $1,000 plus or sit for a while until we sort it out. Ms. Sargent, your client has not appeared. Mr. Belagano, your defendant, has not appeared. I find they're both in contempt and issue bench warrant cash bonds. So you're both free to go on about your business. All right.
Thank you, Your Honor.
Oh, thank you.
All right. Ms. Hamilton, that leaves us with you. And once again, you are here and the defendant is not. This is file 21320. It's entitled Doris Hamilton versus Turnkey Builders and Dylan West. I did a default judgment against, I'm looking for the actual judgment, Turnkey Builders and Dylan West in the amount of $1,538.25 and $1,695.80 when I added in the costs. That was May 24th. Well, too much time passed anyway, but the defendant has filed a motion to set aside the default. And I don't know whether he paid the fee for it or not, but more than 21 days had passed. Maybe not, June 22nd. Anyway, he filed a motion to set aside the default, and he didn't show up for the hearing. It was not within 21 days of the motion to set aside the default is denied. Defendant failed to appear. Original judgment for $1,695.80 stands. Ms. Hamilton, what those two cases just before you did is they filed what's called a discovery subpoena to compel the defendant to come into court. Normally we do a discovery subpoena and then I might do a show cause hearing. In each of those cases, I simply issued a bench warrant. They were personally served, and Mr. Steger already has a warrant, an open warrant for his arrest. But in this case, he still owes the $1,695. His motion to set aside the default, A, was filed late, and B, he didn't show up to hear it. So you have a judgment against Turnkey Builders LLC and Dylan West. As to
What's it called?
Excuse me?
What was it called to file?
A discovery subpoena.
Thank you.
And eventually, rather than go to jail, we don't have debtor's prison. You can't go to jail for not paying a debt. However, when you get a subpoena to appear for a court hearing or you don't show up, that's contempt, punishable by a bench warrant with a bond. And so as long as they show up, they're not necessarily subject to being arrested. We don't put people in jail for not paying a debt. We do lodge them for not showing up for a lawfully scheduled court hearing that they were personally served notice of. So he isn't here to prosecute his motion to set aside the default. Judgment stands as to Turnkey Builders and Dylan West. All right. Thank you. You're good to go.
Okay, thank you.
Okay, I think that finishes our very long day, or maybe just seemed like a very long day. Because there's no air conditioning in here. All right, we'll shut off the live feed, shut off the recording, make our notes, and get on to our next batch of business. Be back